Hello, I'm Jennifer Campbell, one of the co-chairs of the Executive Committee of the Beverly Hills Bar Association's Trust and Estates section. Welcome to our program today entitled From the Inside Out, Psychological, Legal, and Ethical Aspects of Elderhood. Today's program is co-sponsored by the Beverly Hills Bar Association's Mediation section, and we thank them. Before we begin, I have some housekeeping announcements. You will receive your MCLE certificate shortly after the program. Please take a moment to complete the survey that is included with your certificate. And now, a word or two about our wonderful sponsors. The Trust and Estates section is sponsored by the Sanborn team, Geffen Real Estate, Glen Escrow, California Title Company, and Manufacturers Bank. First, let me introduce Nancy Sanborn and Brian Joy of the Sanborn team to say a few words for us today.
Thank you, Jennifer. Thank you to the Beverly Hills Bar Association for your continued support. We have supported the Beverly Hills Bar now for almost 15 years.
So we wanted to take a few minutes to share a case study in the hopes that this situation does not happen to you. When dealing with property sales through probate, trust, or conservatorships, there are a few details that are often overlooked. We'd like to touch on the importance of delivering all disclosures to your buyers prior to them submitting an offer.
So most importantly, this is about the 9A report. The 9A, for those of you that don't know, is a City of LA report, residential property records, that costs about $72 and it takes about 10 days to get. The buyer must acknowledge and approve the 9A report prior to closing escrow, and that applies to all types of sales.
So we currently have a property in escrow that was marketed as a triplex. But the tax assessor shows it as a triplex. But when the report came in, the 9A showed it was only a duplex. Since we had the report prior to the buyer accepting the seller accepting the buyer's offer, we were able to get the buyer to sign off on the discrepancy, which made the seller safe from the liability of this. The takeaway for you is to make sure that the real estate agents you are working with order this report in advance. Please note, we are talking just about the City of LA. Other cities have different reports.
In addition to the 9A report, there are other disclosures for a fiduciary or executor that are required to deliver to the buyer. And just as important, many disclosures that are not required and should not be delivered to a buyer. If you wish for a copy of the disclosures that you should be giving, please just email nancy@sanbornteam.com and we'll send those to you.
We put that in the chat. Hope that helps you with your next sale. Thank you for your time and have a great program.
Thank you, Nancy and Brian, and thank you to the Sanborn team for being a wonderful sponsor. In addition to the Sanborn team, the Trust and Estates section is also sponsored by Geffen Real Estate. Orit Gadish, broker and owner of Geffen Real Estate, is the author of the Practitioner's Handbook for Probate Real Estate. Orit is offering a complimentary copy, paperback copy of her book to practitioners in exchange for feedback. And if you would like the book, she appreciates a review to be included in the next edition of the book. Text Orit at 323-606-1919 if you're interested. The book is available for sale on Amazon, and you can take a look at a few pages by clicking the Look Inside link. Glen Escrow is also one of our wonderful sponsors. Marcine Klein is a full-service escrow officer specializing in probate, trust sales, conservatorships, and both court and independent administration of estate act transactions. On a daily basis, Marcine works to ensure that even the most challenging escrows close smoothly and that her clients are beyond happy with their experience at Glen Escrow. California Title Company. California Title Company provides comprehensive and timely title insurance protection for home buyers, including first-time home buyers, sellers, veterans, and military personnel, seniors, real estate agents and brokers, mortgage lenders, and commercial real estate professionals. Manufacturers Bank wants to simplify your banking. Let Manufacturers Banking do it for you. Manufacturers Bank has a dedicated trust and estates banking team with experience to handle all your banking needs. Please contact Brian Flores, Vice President and Senior Relationship Manager, for more information. And now, without further delay, let me introduce David Shapiro, who will give us this month's legal updates. David, you have the floor.
Thank you, Jennifer. I'll start with Haggerty v. Thornton, Court of Appeals case D078049, 4th District, filed September 16th, 2021. Jeanne Birch created a trust in 2015 that reserved the right for her to amend the trust by an acknowledged instrument. Birch signed an amendment in 2018 and sent it to her attorney, but did not have it notarized. Birch died later that year. Birch's niece, Brianna Haggerty, brought a petition alleging the 2018 amendment was invalid. The probate court found the amendment valid because the provision in the trust did not state it was exclusive. Did not state it was the exclusive method to amend the trust. The Court of Appeals affirmed, although Probate Code Section 15401 provides that a trust may be revoked by any method of revocation provided in the instrument or by a writing signed by the settlor and delivered to the trustee. A 2012 case, King v. Lynch, held that the trust agreement provided for a method, if the trust agreement provided for a method of amendment, it must be followed to amend the agreement. However, the Court of Appeals relied on the principle that the power of revocation implies the power of modification, and the court distinguished King v. Lynch, finding that the Birch reservation of rights did not appear to intend to require her to amend the trust only by the specific method described in the trust agreement. The next case, Estate of Benny M. Wall, Court of Appeals case C087730, 3rd District, filed August 24th, 2021. After the decedent Benny Wall died, his wife, Cindy Wall, petitioned the court to determine that a trust titled in Benny's name but acquired during their marriage was community property. Benny's children from his first marriage objected, claiming that pursuant to evidence code 662 that provides absent clear and convincing proof to the contrary, ownership is set forth in the legal title, the property was the decedent's separate property. The wife raised Family Code Section 760, which provides the property acquired during marriage is community property, and Family Code Section 721B that provides that there is a rebuttable presumption of undue influence when one spouse obtains an advantage over another in community property transactions. The court ruled for the spouse, finding that while Evidence Code Section 662 does apply for civil matters, a different analysis applies for a marital estate, and the Family Code Sections 721B and 760 were not rebutted because the children failed to show that the purchase and titling of the home were transactions freely and voluntarily entered into with full knowledge of the relevant facts. The Court of Appeals found that Family Code Section 760 did not prevail over the presumption that ownership is set forth in legal title under Evidence Code Section 662. However, the court found that Family Code Section 721 was applicable because the spouse presented substantial evidence of constructive fraud to support the probate court's finding of undue influence under Family Code Section 721. Next, Pierce v. Briggs, Court of Appeals case F080403, 5th District, filed August 4th, 2021, modified and certified for publication on August 31st, 2021. Ruth Briggs had 2 natural children. Ruth later married Jack Briggs, and they had 3 adopted children. Jack and Ruth bought a property on Gibson Street in Bakersfield as joint tenants. Ruth created a will nominating Jack as the executor that provided that all property owned by Jack and her, including property held in joint tenancy, was intended to be community property, and her share of the community property was to be distributed equally to her 2 natural children and their 3 adopted children. After Ruth's death, Jack refused to probate Ruth's will, but created his own will and trust that provided the assets would be divided between their 3 adopted children. 14 years after the death of Ruth, Jack died. Ruth's natural children brought a suit on behalf of her estate for Ruth's estate's community property interest in the Gibson Street property. The trial court found that the natural children failed to establish Ruth's estate's claim because Ruth's will did not sever the joint tenancy, so Jack received the property on her death. The Court of Appeals affirmed, stating that the language in the will that the property was intended to be community property did not reflect a clear and unequivocal intent by Ruth to sever the joint tenancy. The will did not specify any particular property. It did not clearly provide that Ruth intended a unilateral severance of the joint tenancy and co-owned property to be irrevocable during her lifetime and to take immediate effect. Finally, we've got Hudson v. Foster, Court of Appeals case B300017, 2nd District, filed September 7th, 2021. Nigel Hudson was severely injured in a car accident, and he received a personal injury settlement. Hudson's friend Lucas Foster became Nigel's general conservator. Foster filed a first and final account and petition to approve the account and terminating the conservatorship, stating that he received over $9 million and dispersed over $4 million. Foster did not disclose in his petition that 28 checks totaling over $550,000 shown as paid to third parties were in fact paid to Foster and his company, and the purported recipients had not received payment. The court entered an order approving the final account. Over 4 years later, Hudson filed a motion to vacate the order approving the final account alleging fraud and misrepresentation of material facts. Foster argued that Hudson had access to the bank accounts and other notice, and under Knox v. Dean, a party seeking to set aside a judgment for extrinsic fraud must show the party could not have reasonably discovered the facts prior to entry of judgment. The probate court found that Hudson had sufficient information and had not shown he acted with reasonable diligence in seeking to vacate the order based on information he should have known. The Court of Appeals reversed, ruling that Foster had a confidential relationship and a party may obtain relief from a judgment when the other party concealed facts in violation of a duty arising from the confidential relationship. Moreover, the Knox court misinterpreted the requirements for establishing extrinsic fraud in conservatorship cases. Under Probate Code Section 2103B, orders releasing conservators are not final when obtained by fraud, conspiracy, and misrepresentation contained in the petition or account. I now turn it over to Kevin Harrington to introduce the esteemed speakers.
Thank you, David, for those legal updates. Hello, my name is Kevin Harrington, and I am the program co-chair of the Trust and Estates section. We are privileged to have with us today Bruce S. Ross and Dr. Eileen Gallo-Ross. They will share their expertise with respects to numerous estate planning and succession issues involving elderly clients, including psychological concerns affecting the elderly client and legal and ethical aspects of representing the elderly client. Bruce has more than 45 years of experience with high-value fiduciary litigation and the resolution of estate, trust, protective, and financial elder abuse proceedings and disputes, both in the United States and internationally. He was recently named a statesman by his peers in trust and estates law according to the Chamber's high net worth, which ranked him the highest tier for his lawyers handling private wealth disputes. In addition to his decades of experience as a trial lawyer, Mr. Ross has worked as a mediator since 1996. Eileen is a licensed psychotherapist who has researched, written, and spoken about the psychological and emotional issues of family wealth and the challenges of raising children in an affluent environment for more than 30 years. As a private practitioner, Eileen has counseled patients, including children and parents, in coping with challenges generated by wealth and living financially responsible and fulfilling lives. I understand that Bruce and Eileen have a great program for us today, and they'll try to answer any questions that you have at the end of the program through the Q&A box. I will now turn it over to Bruce and Eileen.
Thank you very much, Kevin, and welcome everybody. It's a privilege to be here today. I'm sorry we can't be with you in person, but Zoom certainly is an alternative. And we'd like to share with you some thoughts about a program that we've entitled From the Inside Out, Legal, Psychological, and Ethical Aspects of Elderhood. Let's get started because we have roughly an hour. And if we have a little time or if anybody wants to stay on at the end of our program, we'll be happy to try and answer some questions that we suggest you send to Kevin for our use later. So let me turn the program over now to Eileen.
This is an exercise we're going to activate here. This is an exercise that was done with first-year medical students at University of San Francisco Medical School. The professor actually distributed papers to the students and asked them to write spontaneously some words, and then he collected their responses. What he did is he showed them the word old, and he asked them, what words come to mind when you see this word?
And I'm the student in this example. I'm going to start with wrinkled, bent over, slow moving, bald. That one I'm not. White hair, a little bit, weak, fragile, frail, sick, sad, pejorative, and lonely.
And some other responses were grandparent, and somebody actually wrote smelling of mothballs and stale smoke. And then the professor said, when you see the word elder, what words come to mind?
Respect, leader, experience, power, money, knowledge. And it's important, I think, to mention here this quote from centuries ago by Socrates. I enjoy talking with very old people. They have gone before us on a road which we too may have to travel. And I think we do well to learn from them what it is like.
Louise Aronson is a geriatrician at the University of California at San Francisco. And she really believes that we are all old people in training. She's rethinking the third act of life and encourages us to look at the final third of life with the same concern and curiosity as the first 2/3. Now, although most of these concepts that we're going to discuss today focus on the medical community, we can certainly apply these concepts to the financial and legal communities as well. Dr. Aronson wrote an article in The Atlantic in which she talked about ageism as discriminating against people because they are old. And she talked about the disregard for the elderly, she said, is woven into the American culture. And when we did this as a live presentation, we would ask for comments from the audience, and people did really agree with this concept. Some of the reactions to the virus range from, if we think about a continuum going from one end to the other, the reactions have a wide range. On one end of a continuum, there's been this nicknaming of COVID as the boomer remover. And we had neither one of us had heard that before, but it's out there, the boomer remover. At the other end of the spectrum, there are grocery stores that are reserving special times for elders. So they're showing respect this way. Dr. Aronson said that as she was growing up, she would think of the population pyramid, where the children were at the bottom and then the adults, and then at the very top were the elders. But because now people are leading much longer, fuller lives, and she sees it as the paradigm is more of a population column where there are children, adults, and elders. Elders are living a lot longer, and so they're part of this of a growing population. Drugs and diseases behave differently in older bodies, she says. And there's something here that I didn't even know about. Body temperature is lower, so that a 99 degree in an elder could be a fever. So by understanding some of this essential information, we can all help to create a less ageist culture. Now, how many pediatricians do you think there are in the United States?
We got several different answers to this question. Again, I'm going to just throw these out because we can't chat with you, obviously, during this, but we heard 20,000, we heard 70,000, we heard 100,000, and I will now put up the actual number. which is, this is as of a couple of years ago, of course, but this is 70,000 pediatricians. So the next question, Eileen, is what about geriatricians? What are geriatricians?
This is a really interesting situation. In 2012, a group of doctors at Johns Hopkins made a video called The Unknown Profession. They walked around Baltimore and asked a diverse group of people, what is a geriatrician? Most people had absolutely no idea. They tried to guess. Did it have something to do with diet? Did it have something to do with nutrition? Did it have something to do with gerrymandering because they thought it was a geriatrician? It sounded like gerrymandering. And Bruce, you think what's the funniest one?
My favorite answer was a geriatrician is a person who scoops ice cream at Ben and Jerry's.
So actually, the amount of geriatricians in the United States is 7,000. It didn't become a specialty. Geriatrics did not become a specialty until 1978. Now, psychoanalyst Erik Erikson in the 1950s, he is well known for his developmental paradigm involving consecutive stages of development from birth to later adulthood. After he died, his widow Joan added a 9th stage, which she titled Very Old Age, because so many people were living longer. Incidentally, she was a big part of Erikson's life. She helped him and worked with him, developing his ideas and his concepts during his lifetime. Joan's advice to the very old she said, go on becoming.
Which is I think, great advice. It's also, just as an aside, the title of Michelle Obama's book.
Becoming,
yes.
Okay, next one. Here we see the expected phases of dependence and independence. You see the childhood and elderhood as more dependent, and the wide range of adulthood as independent. And then Dr. Aronson talks about the young old and the old and those in between. The young old, she refers to people who are 65, 70-ish, and the old past 90. Now, microaggressions are casual degradations. Some of these are intended and some of them are unintended, but they are received and experienced as insults by people, by older people especially. And I remember a few years ago, we were in Tennessee and I had to have a lung x-ray. And the nurse practitioner who came into the room with the results swung the door open and she said, well, how are we doing today? Oh, I guess not too well, or you wouldn't be here. And I experienced it as very infantilizing and condescending. These microaggressions can be verbal or nonverbal. Recently, Bruce, you had a flu shot last year.
Yeah, it's interesting, the kinds of things that come up. And but I went in for a flu shot it was more than a year ago, actually, I think. And I was prearranged with the pharmacy. And when I got there, I said, this is the senior shot.
It's supposed to be double.
And it's supposed to be double the dose. And I basically got brushed off. I said, no, it's not. That's not in stock. They're all the same. Well, not being a medical person, I went ahead and had the shot because I didn't want to go back anyway. But That's just a small but a telling example. A more interesting example, which just occurred, doesn't really function of age, and in my opinion, but it's the kind of thing that all of us, I think, need to be alert to these microaggressions that Eileen's talking about. We were on a plane. We were going to New Mexico to give a couple of programs, and we were talking with a couple behind us who happened to know a couple people, or a judge that I knew, and the gentleman was a surgeon, and his wife then asked me, because we were talking about what we did for a living. She said, "What do you do?" I said, "I'm a lawyer," and her response, which is very immediate, was, "I'm sorry." And I kind of laughed it off, and I wasn't going to make a big point of it. But when I thought about it later, with Eileen's help, because she immediately identified that perhaps as going a micro going toward
a macro. I would say it's a macro.
Basically what she was, with one word, with that sentence, she was trashing 50 years of my practicing.
Sometimes it takes a while. It takes, like when I was with the nurse practitioner. And, it takes a minute or two to digest what's happened. You're so surprised. And that's probably with the flu shot. And also, on the airplane, of course, I recognized it immediately. And it's just sort of hostile.
And I think the point, by the way, without meaning to be, I didn't ascribe any bad faith to the individual who said that. But I think there's lessons here for all of us, particularly when we're dealing with elderly clients, on how we interrelate with them and how we treat them. And we have a little video.
Wait.
Unless Eileen wants to interject one other point.
Yes,
Sorry.
I wanted to say something about nonverbal microaggressions, and one that I was very guilty of years ago. I was going to a party, and it was up quite a few stairs, and a friend, a couple, an older couple that we knew were going up the stairs, and I reached out to help her go up the stairs by holding her arm, and I didn't ask her, and she turned to me and she said, "I don't need your help. I'm not that old." And I realized how insensitive I had been. So I think that helping without asking can be experienced as a microaggression. And I now, after that experience, I always ask, "May I help you? Could I help you, please?" Instead of just reaching out.
So let's hear from an actual client who may someday be in your office.
Soon after my husband's death, I went in to meet with the financial advisor and my accountant to discuss my husband's trust and financial future. I was pretty anxious about it because it's the first time I'd had to talk to anybody about the finances or the future. And the attorney and the accountant spoke directly to each other. And I was realizing I was not in the picture at all. It was not important. But it was the first time I realized that I was alone in this situation. And it was an important change in my life, and one that I needed to be aware of and didn't know how to handle. Absolutely did not know. So it was an awkward, embarrassing, and at the same time infuriating situation for me. And one, unfortunately, that has happened to me more than one time. And I think the second instance that I remember so vividly is I had minor outpatient surgery. And I was finished with the procedure. I was sitting on the gurney in the hospital room. My daughter was there with the nurse, and the two of them were discussing the fact that I had just had surgery. It was a pretty scary procedure, and I was not medicated. And the nurse directly turned her back to me and started speaking to my daughter. Evidently, they knew everything and I didn't know anything. And I sat there watching them and talking about me as though I were not in the room at all. And finally, I stopped the nurse and said, "Excuse me, I'm right here. I'm the patient. I'm right here in the room with you. I need to hear what you're talking about. I can't understand you. I can't hear you. And I need this information." And she was embarrassed. And I was not very pleasant about it because I felt insulted. I really felt insulted and angry and disappointed and every adjective you can think of. And I think you need to speak up for yourself, because otherwise it's not going to happen and you're going to be very much alone.
So sometimes words and actions can have scars on the psyche.
Want to mention a quote here. This is a 97-year-old man with a painful left knee goes to a doctor who takes a history and does an exam. There's no sign of trauma, and the doctor says, "Hey, the knee is 97 years old. What do you expect?" And the gentleman says, "But doctor, my right knee is 97 also, and it doesn't hurt a bit." This just another small example of what Dr. Aronson would call an example of a combination of social prejudice and, frankly, medical laziness.
So as we have said, ageism is the stereotyping and discriminating against people because they're old. Now, during the estate planning process, with meetings, you're having meetings with older people, with anybody really. One of the underlying parallel processes is, this life review. What have I done with my life? What are my relationships like? Are there any estrangements? Lots of these questions are popping up in people's minds as they're thinking, as they're proceeding during the estate planning process. Also, another concept to keep in mind with older people is that there's a long list of medications that they take, and there's, of course, risks of side effects increase with age. In 2018, the CDC vaccination schedule was this: 17 subgroups for kids from birth to age 18, and 5 subgroups for adults. So people over 65 were all in the exact same group, even though they differ biologically and also as far as their immune function. Nowadays, things are a little different post-pandemic because we have a schedule that favors and it's respectful of older people. Mary Pifer, who is really a cultural psychologist, she's written books on families and culture, and her latest book is on women and aging. And she says really that the most important, significant experience that she's having as she gets older is this ongoing grief and loss that as people die and become ill. Aging begins at birth. It's an ongoing process of adaptation to our changing body, but also to social and cultural situations. And as we grow older, we need to restructure our identity to who we are right now. Our children grow up, they get married, they start their own families, or they move out and start their own relationships, their own families. And we no longer, as elders, are the hub for our children and our families. And sometimes, many times, we're on the periphery of their lives. One woman who was a single mom and had 2 sons, and she used to have all the holiday parties and the bar mitzvah, the Hanukkahs and the Passovers and the Thanksgivings. And now she goes to her daughter-in-law's brother's families, and that's where she goes for Thanksgiving. And she calls herself a satellite, but she's okay with it. She's accepting it. We have to keep an open mind as we grow older, and we have to be adaptable.
So let's turn now to a classic dichotomy: the adult individual's interest in autonomy and the potential and often growing vulnerability of each of us as we get older. This section, we borrowed a title from the Trackman lecture. It was given a couple of years back by Professor Mary Radford of Georgia State, who's an ACTEC fellow, also former president. And she gave a very interesting talk about this very topic. And we want to turn to this issue now.
What Mary talked about in her lecture was balancing the vulnerability of elders with their quest for autonomy. Basically, she said, what if Granny's cognitive abilities are not reduced and she can afford it and she truly just wants to gamble? Should her family keep her from doing that? Should she be able to do it because she can afford it and she wants to do it? So the balancing of vulnerability and autonomy is very significant. How to protect the vulnerable without jeopardizing their autonomy. We have 3 anecdotes depicting this concept. There's a couple in their early 90s who are divorced, have been divorced for many, many years. They have 1 child, an adult daughter, but they have stayed really good friends throughout the decades. And they both are in the film industry, retired, and they love to meet and go to a movie once every couple of weeks. And they meet, they live about 6 miles apart, but they take a car or a driver and meet at the theater and in the afternoon, and then they walk to a neighborhood restaurant for dinner and they discuss the film. It's been a highlight of their life as they've gotten older. Well, one day, the man who needs to use a walker, they were leaving the theater and they sort of fell over each other and ended up, on the floor. She had a medical alert button on and pressed it, and the medical people were there very, very quickly. They were not hurt, and they were able to, leave the theater and go have a bite to eat. But they were very shaken up about it, and they didn't want anybody to know about it. They wanted no one to know at all. They were sort of ashamed about it, and they were afraid if their daughter found out that that would impair their, their freedom. And they pleaded with me, please don't tell my daughter, don't tell my daughter. And of course, I did not. No, let's skip this one.
Yeah, we're going to skip this in the interest of time and go to this gentleman who, as you see, is comfortably ensconced in a scooter. Fascinating story. This was in the New York Times probably a couple of years ago. The article was headed, "Aging Parents' Willfulness May Be Mismatched Goals." And it discusses an elderly gentleman who insisted on driving, perhaps past the time which he should have, and points out that he was very stubborn. And of course, stubbornness is a trait that all of us have to some extent, and perhaps as we get older, we get more stubborn. And in some respects, that can be a positive trait, give you the ability to resist undue influence. In other cases, it may have negative implications. And the discussion included the fact that arguing, that is, the children's arguing with grandpa, didn't help, and reasoning with him didn't help either, because he was insistent on driving his car, despite having knocked off a few side view mirrors and a few other things.
Scrapes.
So they decided, we know what we're going to do. We're going to send him to the DMV. This was New Jersey Department of Motor Vehicles. We're going to send him to the DMV, and he'll flunk the test, and that'll be it. His keys will disappear, and we'll be done. Well, they took him to the DMV, and he aced the test. So that wasn't going to work. So basically, they ended up taking an incremental approach to this, and then they decided that there was an alternative. And so here is the alternative. He has this beautiful motorized scooter, and according to the article, he drives it a couple of, not even 2 miles to on Applebee's. At least that was true 2 years ago, or 3 years ago. He drives it to Applebee's and gets to meet with his friends. And occasionally he stops at the grocery store on the way back and picks up some groceries. So the only concern that his daughter mentions is there's this apparently major intersection that he has to drive through. But in any event, I think it's an example of how working cooperatively and with an elderly person, we can give her or him give attention to their autonomy, to their wish to be independent. At the same time, try to have some guardrails that if they're not completely enamored of, at least they'll accept. So we'll turn now to a discussion of delirium and dementia. And these are important, obviously, in the context of estate planning generally, but particularly with individuals who may be, but are not necessarily subject to undue influence. And I think it's important for us as lawyers to remember that all of us are influenced. All of us are influenced. So the question is, is the influence being exerted undue? Unfortunately, here in California, I'm not going to spend a lot of time on this, but you all know that we have a very extensive definition of undue influence now in the Health and Safety Code, and a lot of case law on this subject. And essentially, we need to look for, among other things, excessive persuasion coupled with participation in the act and undue influence. But at the same time, it's important for us to understand the very important distinctions between delirium and dementia.
Both delirium and dementia are confusional states, changes in a person's thinking and cognitive ability to function. But delirium is acute, so it comes on suddenly. It's usually associated with an illness, can be a medication reaction, can be an acute illness, can be a major change in environment, like ending up in the hospital. Delirium tends to be short-lived, so can be hours, can be days or weeks, although we're increasingly learning that it the longer it lasts, the longer the long-term effects of it are. But by definition, if a person becomes confused pretty quickly over hours to days, that is delirium. This in contrast to dementia, which is a chronic condition of confusion and decreased cognitive ability that generally comes on very slowly and gradually, unless it occurs, for example, as a result of a stroke. But then also you have some delirium maybe before you get to the dementia. But dementia is insidious, very slowly progressive in most cases, and is very different from delirium, except that in both cases, people might be confused. They might have trouble paying attention. They might hallucinate. They might become sort of more active or less active.
So we've included a slide here that gives you a comparison, side-by-side comparison of the aspects of delirium and how they are similar to, but also different from dementia. And I think a helpful tool to understand what you may be dealing with. Before we move into a discussion of some of the legal and ethical issues surrounding representation of elderly individuals, I wanted to put this quote up from Mark Twain. It is the epitome of life. The first half of life consists of the capacity to enjoy without the chance. The last half consists of the chance without the capacity. Now, giving due credit to Mark Twain, who is an incredible humorist, I think most of us today would disagree with this and
Yes.
strongly assert, as I hope we've been suggesting in our talk so far today, that the elderly are just as entitled to their independence and autonomy as anybody else, and also may, in certain cases, need protection from those who would take advantage of them. That gets us into the topic of elder abuse, undue influence, the potential for elder abuse. And I want to spend a few minutes about this before we wrap up. This is a question. Again, this comes from Professor Radford quoting Willie Sutton. Why are seniors so often targeted? Because that's where the money is. And in fact, if you look at the statistics, it's really incredible the amount of money that's in the possession of our senior citizens and the potential for abuse of those finances.
You know, one thing that Mary Radford mentioned in her paper was that there's a part of the brain as people age that becomes less active. And because of that, they seem to be a little more trusting. Older people, because of this less activation in this particular part of the brain, they are more trusting, and so they're easy targets sometimes.
And in that regard, this quote, "The elder abuse happened to me, Mickey Rooney, and if it can happen to me, it can happen to anybody." This comment, which is about 10 years old now, was given by Mickey when he testified before the United States Senate after our work in getting him out of an extraordinarily abusive situation. But the point he makes and resonates in my mind today is, if someone of that stature, because he's one of the longest lived, most esteemed actors in our history, if it can happen to him, it can happen to anybody. And sadly, it does happen to far too many people, and it's still, frankly, a scourge with respect to our elderly and more vulnerable citizens. So I want to turn now to a hypothetical problem. This is based on an actual case from many, many years ago, and I'm going to read this to you. You have a longtime estate planning client, Ava, a widow, 87 years old, with very mild dementia. She has no close relatives. Her current trust gives her entire estate to the Albuquerque Home for Bewildered Estate Planning Attorneys, a qualified 501c3. And I forgot to check this, but I think there's an affiliated charity for Beverly Hills Bewildered Estate Planning Attorneys. I'm not sure about that. We'll have to check the IRS publication 990. Ava comes to your office with a gentleman, Sam, who she introduces as her boyfriend and whom she tells you she met 4 months ago. After you have excused Sam from the conversation, Ava advises you she wants to modify her revocable trust to give 40% of her trust assets to Sam. After a brief discussion, you come to believe Ava is being unduly influenced by Sam. You entreat Ava to reconsider her plan. Ava refuses to change her mind and tells you she intends to find another estate planning lawyer, quote, who will actually listen to me, close quote, and directs you to turn over her file to her. So here's the dilemma. What should you do? What can you do? Does it matter in what state you practice? Now I'm going to come back to the hypothetical and tell you what I actually did. Fortunately, the statute of limitations is run on me. But before we do that, I want to talk about the rules of professional conduct. And sadly, the most important rule with respect to dealing with a client with diminished capacity, and I have noted here that the capacity is diminished. She has dementia mild at this point, we think, but we don't know for sure, and it's a continuum. But Model Rule 1.14, which is the ABA prescription, it's been around for many, many years. The lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client, no problem there. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm unless action is taken, and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action. And finally, information relating to the representation of a client with diminished capacity is protected by Rule 1.6. Well, the way this rule plays out in the minds of the ABA, and this is an older opinion which refers to disability, in other words, or diminished capacity, but 89-1530 says the disclosure by the lawyer of information relating to the representation to the extent necessary to serve the best interests of the client reasonably believed to be disabled, i.e., with diminished capacity, I've added, is impliedly authorized within the meaning of the Model Rule 1.6, confidentiality of information to disclose. Thus, the inquirer may consult a physician concerning the suspected disability or diminished capacity. Now, note the use of the words impliedly authorized. The problem with that, at least with respect to this hypo, is the lawyer hasn't been impliedly authorized. In fact, the lawyer has been expressly told not to disclose the information or not to do anything with what she reasonably believes now, which is that this fellow is going to make off with a big chunk of her estate. So we have here in California a problem, which was recognized years ago. And indeed, the estate planning, probate, and trust section has recommended legislation to deal with this problem because in California, we take a very broad view of the duty of confidentiality. And there is a state bar opinion, which I happen to disagree with and have disagreed with for years, which says that you can't disclose even if you would be protecting the client. Because the information you've been given is confidential. So fast forward a bit, that legislation did not pass, and it was, frankly, I thought, a very good bill balancing confidentiality of information, the duty under 1.6 with the ability to you borrow the words from Justinian, do no harm, and in fact, prevent some harm from occurring, such as the successful exercise of undue influence. So, as you all know, finally, after decades, California decided to adopt at least the numbering and in many respects, the actual language of the ABA rules of professional conduct. However, despite the recommendations of the probate bar, meaning us, all of you, that recommendation was rejected by the Supreme Court, and therefore it's one of the only ways in which California does not conform its rules of professional conduct with the ABA. So we have no 1.14. There are a couple of opinions that I think are helpful and that disagree with the state bar opinion. But at the moment, we have, a conundrum here for we lawyers here in California. So in that sense, it does matter in what state you practice, because a good many other states permit disclosures in this kind of an instance. So let's, and by the way, before I leave this topic, let me mention the Guide to the California Rules of Professional Conduct for Estate Planning, Trust, and Probate Counsel. This is a project that I was privileged to initially co-edit with Susan House many years ago. It's now taken over by the California Lawyers Association, and it's in its 4th edition. So I think all of us are well advised to have this on our shelves to refer to, because it also references the ACTEC commentaries on the model rules of professional conduct, but is directly deals with these various ethical issues as they are dealt with here in California. So having said that, let me mention a couple of other approaches here. What about asking the client or getting the client's approval in advance to authorize this information if the client becomes in need of assistance, material assistance, to resist undue influence or otherwise protect her financial or personal assets. This language is from the ACTEC engagement letters project. Those are all they're all in the public domain, because both the ACTEC engagement letters, which reference the ACTEC commentaries, were funded and are funded by the ACTEC Foundation, a charitable organization. So you don't have to be an ACTEC fellow to go on the web and refer to all this information. And I feel pretty strongly about all of this. I've been involved now for too many years with these projects, but I think there's a lot of excellent information here. And one of the things here is this proposed letter, which you could definitely call an advance waiver or authorization to disclose otherwise confidential information. And I think you can read this on the screen, but quickly, if concerns develop about your capacity, meaning to the client, you authorize us to do the following: to communicate with your immediate family, your physicians, your accountant, and your other advisors, and to disclose information to act in your best interests and carry out your wishes previously expressed to us, to represent any person you have chosen to be your legal representative, and if necessary, to petition the court for the appointment of a fiduciary to protect you and your assets. Now, I think, frankly, number 4 goes a little too far, but the notion of dealing with this topic with your client in advance and pointing out to her the potential for problems is well worth considering when you're dealing with aging clients. I want to also reference a couple of cases in this area, because they will give us some input or things to think about as well. Dunn versus Patterson is a case from Illinois. The lawyer there, Mr. Patterson, was representing an elderly couple. He sat down with them and drafted a revocable trust. And then he pointed out to them the potential problem if one or both of them became, significantly diminished in mental capacity and cognition or subject to undue influence. And so after this discussion and with their approval, the document included a clause that said that the trust agreement could not be amended unless it was with after his review and approval, or the approval of the court of appropriate jurisdiction. And this was true whether or not he was still their lawyer. Well, the inevitable happened, and he went to, the Dunns went to another lawyer who immediately wrote Mr. Patterson and said, the Dunns have changed counsel. It's me now. Please turn over your file. Mr. Patterson initially said, look, I'm willing to do that, but I want to meet with him personally first. The lawyer told him to buzz off, and one thing led to another. And then Mr. Patterson filed a lawsuit with the court, in effect against his clients, but seeking a declaratory judgment that they couldn't amend this document until they'd done one of two things, either consulted with him and gotten his approval or gone to the court. The Dunns obviously didn't react very happily to that, so they sued, they counterclaimed against Patterson, and at the trial level, Patterson got blitzed. Was told he was acting completely without authorization of his clients. He violated Rule of Professional Conduct 1.2, dealing with scope and allocation of responsibility, and he was sanctioned. So he took it up on appeal, and on appeal, the case was reversed. The appellate court said that he had not exceeded his authority as a lawyer because he had discussed this issue with the clients. He had explained it to them in some detail, and they had agreed that this is the procedure which would be done to avoid someone acting not in their best interests or unduly influencing them or subjecting them to elder abuse. So that's rather an extreme example, but it does raise obviously other issues, other ways in which you can protect your clients. So for example, having, the ability to amend the document, but only with perhaps the intercession of a third party. And that was one of the things that the court emphasized there too, and so forth. The second case I want to mention in passing is the Oogster case. This is an example of a lawyer just gone berserk. He did an estate plan for an elderly widow. And then a few months later, when she fired him and wanted to change, he filed a lawsuit against her and pursued it at great length. And the end result, it's an interesting case. It's worth reading, by the way. It's from the Supreme Court of Washington. He was found to have violated 7 or 8 different rules of professional conduct because he had gone way overboard. And what was interesting is there's a dissent where at least one justice said suspension wasn't good enough or bad enough. He needed to be disbarred. So an example of something that none of us would ever consider doing. But I do commend the case for reading. It's an interesting object lesson in how not to act unethically. So let's go back to the hypothetical for a minute. This was, in fact, an actual case I had a good many years ago. And it was, I've changed many of the facts and the names and everything, but the client who had a revocable trust had come into my office and at unannounced, no advance warning. And I was told, we'll call her Ms. Smith. I was told that she was there and she wanted to see me. And the receptionist also told me that she overheard this gentleman, whom I'll call Smith, who went by Colonel Smith And I don't know about some of you, but I have a little visceral reaction to a civilian who's walking around calling himself a colonel. But Colonel Smith, she heard Colonel Smith say to the client, now you be sure and get your file from Mr. Ross. So, and she was in her late 80s. She had a not insignificant estate, and I was clearly concerned about her cognition and her ability to resist undue influence. I had independent evidence that it looked like it was being exerted right there in our office. So I called her back. And we chatted a little bit, and it became even clearer to me that she needed protection. And I obviously knew the California rules of professional conduct, and I knew that I personally was on somewhat slim ice here, as the hypothetical suggests. So I decided that the better, if I had to do something, I wanted to do something that was to her benefit and not to her detriment. And I was firmly convinced that if she walked out of there with the file and Colonel Smith, her estate would disappear in short order. So I called the court, and I got the clerk. I think this was Commissioner Blaylock, a good many years ago, and I said, might I come down and see the judge? And I was told yes. So I went out. I told Colonel Smith, I said, you're welcome to come along too. We're going down to see the probate judge. So we trotted down, and fortunately I was downtown LA. We trotted down to the probate court, and I had a private in-chambers conference with the judge, and I expressed my concerns to the judge, and the judge appointed a guardian ad litem, and from there, it wasn't too long before there was a petition for the appointment of a conservator. So the end result was, in my opinion, what should have happened. Was I running pretty close to the line? Frankly, yes. But on the other hand, I asked myself, at this point, what's more important? And I clearly came down on the side of protecting this client, and in this case, at least, that was justified. Now, there are sure to be similar cases like that, and we do have this issue here in California. So far, I'm not aware of any case law. We just have conflicting ethics opinions. An ethics opinion from San Francisco Bar a few years back, and then, of course, the one I mentioned earlier, the State Bar Committee on Professional Responsibility and Ethics. Well, we want, in the interest of time, to conclude this presentation with what we both think is a really fascinating overall approach to what makes the good life.
Hold it.
Yeah, I will.
Before.
Oops.
Okay. So this slide is actually a reference to the longitudinal study of adult health, which was conducted by Harvard. It began in 1938, and George Valiant was the initial director of the study. And it initially only included men because women were not admitted to Harvard until I think it was the mid-40s. So now Dr. Waldinger, who's a psychiatrist, is the director of this study, which, as I said, has continued since 1938.
What if we could study people from the time that they were teenagers all the way into old age to see what really keeps people happy and healthy? We did that. The Harvard study of adult development may be the longest study of adult life that's ever been done. So what have we learned? What are the lessons that come from the tens of thousands of pages of information that we've generated on these lives? Well, the lessons aren't about wealth or fame or working harder and harder. The clearest message that we get from this 75-year study is this: good relationships keep us happier and healthier, period. We've learned 3 big lessons about relationships. The first is that social connections are really good for us and that loneliness kills. And good, close relationships seem to buffer us from some of the slings and arrows of getting old. Our most happily partnered men and women reported in their 80s that on the days when they had more physical pain, their moods stayed just as happy. But the people who were in unhappy relationships, on the days when they reported more physical pain, it was magnified by more emotional pain. The good life is built with good relationships. Thank you.
So the pandemic has really underlined the importance of making connections and maintaining social relationships for overall health, no matter how challenging. So Zoom and some of the social media is very, very helpful to elders.
So we want to close with another quote from centuries ago. This is Cicero. Old age will only be respected if it fights for itself, maintains its rights, and asserts control over its own to its last breath. And we, as financial and legal advisors, I think, can join with our elderly clients in agreeing that this is a road for living. And I and Eileen want to thank you very much for listening in on our presentation today. I'm sorry we can't be with you. I've raised this as an issue, and I've asked the Beverly Hills Bar Association as our honorarium for a free prime rib, medium rare with horseradish and salmon cooked through for Eileen when you all and we all get together again and renew our acquaintances at Lowry's. So again, thank you all very much for joining us today. We really appreciate it.
Are we taking some questions now?
Thank you both for this informative, and I think it gives us a lot to think about. We've gone a little bit over, but we got one question I think would be nice to finish it off. The question is, your visit to the judge would be impossible in today's judicial environment. What would you do today?
Oh, that's a great question. What would I do today? That takes some thought. Yeah, I don't know if you could. Well, you're right. I mean, today it's a much different environment, and not just because of the pandemic, just the overflowing judicial system that we have. If I had the same situation today, and I don't know precisely what I would do, but I would certainly remonstrate even more strongly with my client. And if that didn't work, it's a tough one. I'd still be reluctant to turn over the file, but that's a question frankly, which I hadn't thought about until just now, and it's a very difficult one because this is a very difficult situation. If we were living in a different jurisdiction, it would be a lot easier to answer because it would definitely be able to protect somebody. One thing that does occur to me, if the client had a close relative, could talk to the close relative without giving out any information more than was needed to suggest that somebody ought to look into the situation, which would be valid clearly in any other jurisdiction without any question at all. So, but great question. Thanks. Or no thanks.
All right. Well, thank you so much. We really appreciate you guys presenting to us today.
Thank you.